see legal headlines all the time, but have you ever stopped to wonder what happens after the gavel falls? How does a single court ruling actually become a law that shapes our lives? Well, in this explainer, we're going to pull back the curtain on that hidden journey from headline to established legal principle. So let's dive right in. This is definitely not a straight line from a judge's desk to a law book. Nope. It's this whole complex ecosystem where journalists, scholars, and courts all play a crucial part. And it all kicks off with that very first step, the headline. That first point of contact for most of us is almost always through the media. And this brings us to the critical, and I think often underestimated, role of legal journalism. You know, in a lot of ways, these reporters are writing the very first draft of legal history. Now, reporting on the law, it's so much more than just keeping score of who won. A legal journalist's toolkit is pretty unique. You've got to have the legal know-how to decode dense jargon, the discipline to be relentlessly accurate, and, this is the tricky part, the skill to make incredibly complex stuff simple. And all of this has to be wrapped in a strict ethical code. And that's because, look, it's not just about having the right skills. This entire field is governed by a very specific set of rules, and they're all designed to protect the integrity of the justice system itself. This is what's so important to get. Legal reporting isn't like sports commentary, right? That's just part of the entertainment. Here, the stakes are so much higher. A single misreported fact could literally destroy a reputation or even sway a legal outcome. And that's exactly why these ethical guardrails are absolutely critical. One of the biggest rules of the road is a concept called sub judice. It's a Latin term, and it basically means under judgment. What it does is prevent the media from publishing commentary that could poison a jury's mind or interfere with a case that's still going on. It's the bright line that separates reporting the facts from trying to influence the verdict. And this all gets formalized in a code of ethics. You can think of it as the official rulebook. Report facts faithfully, present all sides of the story, always presume innocence, and protect people's privacy. It's a really comprehensive guide to make sure journalism serves justice instead of getting in its way. Okay, so the headline breaks. The story is out there. But where does that news story go to be truly tested? Where does it face deep, scholarly, critical analysis? Well, that brings us to the next crucial stage, the world of law journals. So, if legal journalism is the first draft of history, then you can think of law journals as the peer-reviewed, heavily footnoted second draft. These things are the intellectual engine rooms of the legal world. The rare ideas are rigorously debated, refined, and sometimes completely torn apart and rebuilt from the ground up. Their role is vital, and you can really break it down into three parts. First, they publish groundbreaking research. Second, they put existing laws and recent court decisions under a microscope. And third, and this is the big one, they ultimately shape how entire generations of lawyers and judges think about the law. And make no mistake, the articles inside these journals, they are not just abstract academic exercises. They have real-world impact. They can push new legal theories forward, they can pinpoint gaps in our current laws that politicians need to fix, and they can give practicing lawyers powerful arguments they can literally use in court the very next day. But maybe their most powerful role is acting as a crucial check on judicial power. They put the decisions of even the highest courts under a microscope, scrutinizing the logic and making sure that judgments are built on a solid legal and intellectual foundation. That kind of accountability is absolutely essential. So, what exactly are these scholars scrutinizing? What is the actual stuff of the judicial decision? To really get that, we need to look at the underlying intellectual process itself, the art and science of legal reasoning. Legal reasoning is basically the structured process of thinking that connects a set of facts to a legal conclusion. It's the framework that makes sure decisions aren't just based on a judge's personal hunch, but are actually grounded in established law. It's all about answering that one critical question: how does the law apply here? This reasoning generally follows two main paths. The first is rule-based or deductive. That's where you take a general rule, like a speed limit, and apply it to a specific situation. Simple enough? The second is precedent-based, where you compare a new case to similar ones from the past. Now this is the heart of the common law system, where past judicial decisions become a source of law themselves. It's law built case by case, not just written down in one giant codebook. So here's the bottom line. This isn't just some academic game.
This structured, transparent reasoning is the very bedrock of the rule of law. It's what gives our legal system its consistency and predictability. It's what makes sure that similar cases are treated in similar ways.
But this whole system, from the journalist report all the way to the judge's reasoning, it doesn't happen in a bubble. Not at all. It's part of a much larger global conversation where legal systems are constantly learning from and influencing one another. And it is so true. No legal system is an island, especially when you look at the common law tradition. We're talking countries like the US, Canada, Australia, India. Judges and scholars are constantly looking across borders for guidance and for inspiration. So how does that work? Well, it's through this really cool concept called persuasive precedent. A ruling from a court in the UK, for example, isn't legally binding in Canada. It just isn't. But a Canadian judge who's facing a new, really complex issue might look at how that UK court reasoned through a similar problem and find its logic, well, persuasive. And they can use it to help shape their own decision. And if you were to peek inside this global legal library, you'd find that for many common law countries, some of the oldest and most referenced books come from English law. Key publications like the All England Reports, which is just this massive collection of important cases, and Halsbury's Laws of England, which is basically an encyclopedia for the entire legal system, they are still incredibly influential today.
And that brings us full circle. From that initial headline through the intense scrutiny of academic journals, shaped by rigorous legal reasoning and informed by a global legal conversation, this entire intricate journey is what takes a single moment in a courtroom and transforms it into a lasting, stable part of our legal fabric. You see, this whole process is designed to be slow. It's designed to be analytical, to be deliberate. It ensures our laws are thoughtful, not just fast. And that leaves us with a final question for you to think about. In our modern age of instant information and lightning-fast reactions, what's the real value of being this deliberate?